An emergency protective order can change someone's life in an instant, and it's one of those situations where knowing what to expect can make everything a little less overwhelming. Here to break it down is Taylor Reese. She's an attorney with Velez Law. She joins us in studio for the first time today. Thank you so much for joining us today.
Yeah, thank you for having me. I appreciate it.
You know, something like this is like so daunting, right?
Yeah.
This is the last resort. A lot of people don't want to go through this, but let's kind of start with the basics. When someone hears EPO, a lot of people don't even know what that means. So kind of break it down for us at like a kindergarten level. What is an EPO?
Yeah, of course. So an EPO is what we call in family court an emergency protective order. So when you get served with an EPO, that is a temporary restraining order saying, hey, you can't come within 500 feet of this person, you can't communicate with them, you can't text them. It's meant to be a temporary solution until the court can hold a hearing on the issue.
Gotcha. And so if someone is served with one, what's the first thing that they should do?
The first thing you should do is not text the person that's the protected party. If you do that, that can result in possible criminal charges at that point. What you should do is you should call an attorney, tell them what happened in your scenario, in your perspective, and then start to prep for a hearing. Because a lot of times you get served and you might have a hearing in 3 to 5 days after that. It's pretty quick turnaround with an EPO.
Yeah, because I mean, a lot of court hearings, it can take days, weeks, months, but this is like within that same week, it sounds like it could be anyway.
Yes.
So what are some restrictions an EPO can put in place that people might not even think of?
Yeah, so a big one is 500 feet from that person's home. It could be their work. It could be just a place that they like to go. It could also be third-party contact. So you can't text someone else and say, hey, tell Sue or John Doe that I said this. Another part of that is if you have a child in common that's included on that protective order, it could grant that other person temporary sole custody, which is something that's going to impact later on if we get into a custody argument at that point.
Okay, definitely need to keep that in mind. Communication. You kind of hit on this one. You can't just talk to another person to get a message to that person. That is not what we're doing here.
Yeah, if you showed up to court and the court sees a message where you communicated with a third person and said, hey, tell them I said this, or tell them to drop it, that's seen as a violation of the protective order at that point, which could result in contempt of court, could result in arrest. There's a lot of implications to violating a protective order.
Social media.
Social media.
A really big one too.
Yes, and a lot of times nowadays, I'm noticing more often on orders, judges will civically say no social media post, no social media contact. So in this new age where we have people on Facebook, Instagram, all these social media apps, courts are starting to recognize that in their orders.
You mentioned saving text, emails. I mean, they're known as receipts, right?
Yes.
You want to make sure that is all documented too. So in case those are broken, you have proof of that, right?
Exactly. Especially if you are the protected party or if you're the party in which the protective order is against. So that's what we call the respondent. You want to make sure you have messages to show either that this person did threaten you or they did violate the order, or that you didn't threaten this person, that you are innocent. So for both sides, don't delete texts, don't delete call logs, don't delete messages or photos. Keep all of it for your attorney.
Yeah, so important to keep all those documents in order. What are some common mistakes that people make during this whole process?
A big common mistake I see is someone deleting all of their messages because they want to forget someone. Well, then we don't have the proof that we need for a hearing to either get you protection or to show that you didn't actually threaten this person. A big one is someone seeing the allegations in the petition and kind of getting upset, maybe blowing up, and so they act out, and that doesn't help their case when, they're the alleged party who's committed this act. And so that's a big thing I notice when people come to me. They just kind of blow up, and you got to kind of take a beat, call an attorney, because there's a lot more implications to it than you think.
Yeah, and that's exactly why you need to get someone on your team.
Exactly.
Get someone to maybe calm you down, because I mean, no one goes to a lawyer on a good day, right?
Yeah.
Like, it's always a very stressful situation, and you actually specialize in this, correct?
Yes, so I do exclusively family law. And one of my area of expertise is emergency protective orders, which we call EPOs, or interpersonal protective orders, which is IPOs, which is between people who maybe are in a dating relationship or married. I do those, almost every week. So I've done both sides. I've done the party who's seeking protection. I've also represented the person who is the alleged perpetrator of this act. So I've been on both sides of the field.
Yeah, so you know exactly how to help someone out. So thank you so much for stopping by today.
Yeah.
We really appreciate it.
Of course, thanks for having me.
All right, you are welcome. If you're interested in learning more, getting in touch with the team over at Velez Law, you can head over to tvelezlaw.com.